I'm State Senator Anna Terry Flores. I am a state senator in Miami, Florida. And more importantly, I participated in the We the People program several years ago, and our state and my team won the national competition that year. So I know that you all maybe are a little bit nervous, so take a deep breath. You're going to do a great job.
Good morning, Michigan. My name is Gus Chin. I'm a municipal judge from the state of Utah.
Good morning, Michigan. Very nice to see you. I'm Matt Gutwein. I'm from Indiana. I am retired, but I previously taught constitutional litigation and civil rights at the Indiana University Maurer School of Law.
Introduce yourselves.
Good morning. Thank you for being here with us today. My name is Mary Langosh, and I'm a senior from East Kentwood High School.
Good morning. My name is Safa Kareed, and I'm also a senior here at East Kentwood High School.
Good morning. My name is Liza Dreyer. I'm also a senior here at EK, and this is our coach, Mr. Justin Robbins.
Well, great. Thank you all for being here. Thank you for your coach and your teacher. And now we will read your question, which is question 1 today. A result of the decision in Wisconsin versus Yoder is that, quote, any parent guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs, unquote. Do you agree or disagree with this result or the decision? Why or why not? What words, if any, are found in the U.S. Constitution or in state constitutions that protect the right to an education? How have courts balanced religious beliefs with other rights?
While we disagree with the outcome of Wisconsin v. Yoder, we do understand why the court reached its conclusion. It was a victim of a limited court record and lapses in advocacy by Wisconsin. Ultimately, the court's hands were tied, but it provided precedents that fostered hope. With new cases, a fundamental right to education through substantive due process may be on the horizon.
Religious exercise and education were explored by Enlightenment thinkers like Rousseau, who asserted education provides foundational knowledge to produce better citizens. The Northwest Ordinance recognized that religion, morality, and knowledge is necessary for good government and happiness. Federalist Number 1 asserted that the American experiment in self-governance relies on the discernment of citizens.
These issues are not balanced without controversy. For example, the Supreme Court considered the right to free exercise against other interests in cases such as Sherbert v. Werner, which created the two-pronged test to determine the government's burden on a religion. Willie v. Maynard found that obstructing the state motto on a license plate due to religious objections outweighed the state's interest in promoting unity. Employment Division v. Smith used a lower standard of scrutiny on laws of general application.
More recently, Masterpiece Cake Shop v. Colorado tipped the balance in favor of free speech and free exercise against the Equal Protection Clause. Similarly, in Burwell v. Hobby Lobby, the right to religious freedom overcame the state's interest in providing health care.
The framers omitted education from the Constitution, leaving education policy to the states through the 10th Amendment. Today, about half of all state constitutions recognize the need for education, but few ensure its quality. For example, in Michigan's Constitution only asserts that there won't be a religious affiliation in public schools, and that secondary and primary schools will be established.
As a result, the quality of education is subject to the political will of state legislatures and local school boards, and empowering bodies more accessible to parents should benefit smaller communities. However, larger districts often face tough questions due to demographic shifts and budget shortfalls, producing a steady stream of questions for the courts.
In Pierce v. Society of Sisters, the court found that substantive due process through the 14th Amendment provides the right of parents to choose whatever values and alternate education they wish to instill in their children. Similarly, Meyer v. Nebraska ruled that being prohibited from learning certain content, such as German, is also a violation.
Yoder falls short of its promise because it was brought forth as a criminal violation against a parent. It only contemplates the right of a parent to make educational or religious decisions for their child against the state's interest under the concept of parens patriae. This is why groups like the ACLU work hard to cultivate proper test cases, because why and how a case is brought forth matters.
Yoder did not contemplate alternate education options because the Wisconsin superintendent refused the Amish proposal of a mixed homeschool curriculum already utilized in Pennsylvania, while emphasizing the negative influence of English schools as an impediment to students' religious development.
Most importantly, the court ignored the large number of people leaving the Amish order and their inability to acclimate to the outside world because the state of Wisconsin failed to provide sufficient evidentiary proof.
The perceived injustice of this ruling is understandable when one contemplates the ability of an Amish child to choose their own destiny in adulthood. Facing shunning, no finances, and a job market that presumes a high school diploma, the choice to leave the Ordnung is often no choice at all.
In fact, the court alluded that the outcome would differ if the children sought an education against their parents' wishes. While we understand the legal conclusion, we disagree philosophically. There is, however, hope for the concept of judicially recognized right to education.
Recent cases such as AC v. Gina Raimondo contemplated whether the right to civic education exists in 2020. Gary B. v. Whitmer in 2019 set the precedent in the Sixth Circuit, finding that substantive due process right to minimal literacy.
Gary B. has opened the door for other cases to make their way up to the Supreme Court so that they may decide once and for all whether there's a right to some minimal level of education.
Thank you for your time, and we are eager to answer any questions.
Senator, you're muted.
I think you're muted, Senator.
There you go. You're okay. Wait, we still can't hear you.
Okay,
There we go. There we go.
Let me jump in with a question then while Senator figures out that technical issue. You hinted at the right to some minimal level of education. Given the parental role in well-being, welfare, and that responsibility, how do you balance the student's right to a proper education to pursue life, liberty, and the pursuit of happiness against that parental religious responsibility or their belief? You're muted, I'm afraid. Go ahead.
This question was actually debated in Wisconsin v. Yoder, where the court case was actually against the parent who was reflecting their personal religious exercise, and in so doing, kept their children from going to school to receive that education. The state initially believes that the parent is always looking out best for their children, and therefore they kind of already automatically assume that the parent's looking out for their child.
There, to add to what Mary was saying, this is why we believe in the same concept as a philosopher named Brian Barry brought up. We understand legalistically why that outcome came to the conclusion that it did, but philosophically, we also understand that the child's interest, once they grow up after the age of maturity, will no longer be able to become better citizens of society if they were to leave the tradition and the culture that they wanted to, just because they have already been fostered and included in a closed society in a way.
And that's why we believe the best way to go about this would perhaps be to declare some sort of a minimal right to literacy. And then it would be best for the child to go to school up until they get their GED or until they pass 10th grade or 12th grade, excuse me. And the parent would then have the option of whether or not they want to go to a parochial school or another private school, or if they'd be homeschooled, etc. And that's one of the problems with Wisconsin v. Yoder, is they rejected the option to adopt strictly Amish curriculum, similar to how Pennsylvania did. And that would have been the best outcome in our opinion, but that's not how the case was brought forth, unfortunately.
Thank you.
All right, I'll go ahead. Let me shift gears just slightly to what's happening today. So with the pandemic, many schools, high schools, are requiring by law vaccinations for students to return to live education. And some parents have religious objections to those vaccinations. And so in those schools that do not allow religious exemptions, but still mandate that the only way you can come to school is through a vaccination, how should the court analyze those cases? And should the religious objections be upheld so the students can attend even if they are not vaccinated and therefore pose a risk to their fellow students, teachers, and the community?
This question is a prime example of the debate between, or the tension that comes between natural rights and classical republicanism, where the state is looking out for the good of society, while obviously you want to maintain and enforce your own religious or your own expression and your own rights. Due to this, the state can mandate some sort of protection, such as vaccinations, but as seen with COVID, it's now masks. But in order to do so, to lessen the impact on the individual right, they have to take the most narrow way possible.
And this would start through the Religious Freedom Restoration Act, or the RFRA. And that declares that anything that might conflict or create an undue burden on religion would have to go through strict scrutiny. And if you go through this process, the state does have a compelling interest in preserving public health, and they are taking the most narrow way possible. So they do have a reason to require vaccines. However, we only need to get up to roughly 70% to get herd immunity. So those people who do have religious objections would still be able to refrain from getting the vaccine if they wished.
With that being said, we see in past court cases such as Jacobson v. Massachusetts, with the outcome of having or needing a vaccine in order to enter a place such as a public school to benefit the more of the common good, just as Liza and Mary were saying previously. However, yes, because this is a religious objection in a way, you would have to go through RFRA and then follow on to strict scrutiny.
And so do you think do the parents win that argument and therefore their kids get to go to school even though they've not been vaccinated?
In a way, yes. The state wins for the majority of people who don't have a reason to object, but the parents who do have an actual truly held belief, a sincerely held belief as defined in US v. Seeger, they do win in a sense, yes.
Senator Flores, I'm adding 30 seconds to the presentation. Could you check to see if you can ask your question now? It's still not working. Okay, so we'll let Judge Chin.
Thank you. Now, I know one of the questions that Senator Flores was interested in focuses on the issue of gender. What if it was prohibited for females to attend school after a certain age? How would you view that? And how would you address that sort of a provision that prohibits young women from attending school up to a certain age?
Regarding the issue of gender and whether or not you're allowed to attend school, I believe that would go through the Equal Protection Clause, depending on how the case is brought forth, of course. That could easily be argued because the state is targeting a specific group of people, and they don't necessarily have a legitimate interest or a compelling interest in regarding whether or not these children are refraining from attending school. So I do believe there would be a case that would declare that everyone has the right to go to school or to a minimum level of literacy, whether or not they are male or female or in between.
I actually disagree with your statement about them declaring the right to education. I think that more or less the court would probably, in a case like that, would determine that you can't prohibit a female child from going to school. But I think that level, the declaration of a right to a minimal level of education would come from a different court case.
Thank you.
I'll ask a very broad question. What do you believe separation of church and state means?
Separation of church and state was first explored by Thomas Jefferson in his letter to the Danbury Baptist, where he defined it as a wall of separation. And the goal was to try to keep church and state separate as much as possible. And that continues on with our First Amendment rights, saying that we do have a right to free exercise, but there's also no establishment.
With that being said,
Okay, that's time. Sorry, we'd love to hear from you. Congratulations, Michigan. Congratulations to your teacher. You've worked so hard and it was a great presentation. The judges will now give you feedback?
No, we cannot. Lovely. And I didn't do justice to Senator Flores' question. It focused on a religious group prohibiting young women from attending schools. So I made an attempt at that. I do like your approach in terms of the plethora of case authority. You addressed Hobby Lobby, the Colorado case, you addressed local issues. I do like how you approached the substantive due process argument and where Yoda falls short in terms of how it approached the issue of balancing the religious educational aspect compared to the student right. You mentioned RIFRA, which is quite interesting as well in terms of how it applies. Well done in terms of your argument, in terms of your reasoning, and its application to the question that we posed. So very well done.
Boy, I agree. What a absolutely terrific presentation. And what I really loved about it is that you are firm believers in the philosophical need for education in our democracy. And you've recognized the shortcomings right now, in your view, of that right, that it's subject largely to state constitutions, which give it inconsistent treatment. There have been some recognition in federal law, but that recognition has been incomplete. And so you were really putting together an argument for future court cases to have a more robust and rigorous federal constitutional right to education. It was a very intellectually strong and creative argument. I also love your just your real firm understanding of the religion clauses, both the free exercise and the establishment clauses, and the differences between the two. And then, as Judge Chin said, very encyclopedic use of case law. So I thought it was an absolutely terrific presentation, very smart, very intellectual, and you put a ton of work into this. So warmest congratulations to you and your fellow teammates, your coach and your teacher.
Congratulations. Oh, yeah, Senator Flores. We're going to ask Donald Lehner to help you with your audio. But students, fantastic job, and congratulations again to your teacher, and judges. We're going to move you out of your breakout room now. So thank you so much, Michigan. It was so lovely to see you all.
Thank you.